Okay, guys, it is Saturday. It's the 26th of October, and we are going to put in our final amended motion for summary judgment on our bill in equity. Hello to the new people, Julie and Robert, of course. Robert's an older sub. Emily, all of you, I hope that some of this information helps. We've got a couple of things I want to share with you. So let's get started here. We went through this before, but this is called the Clearfeild Doctrine. Let's read this. The Clearfeild Doctrine is stare decisis upon all courts and imposes that an entity cannot compel performance upon its corporate rules unless it, like any other corporation, is the holder in due course of some contract or commercial agreement between it and the one on whom it demands for performance are made, and it is willing to produce said document and to place the same into evidence before trying to enforce its demands. So, once again, everything is commercial. Everything is about the contract, okay? So, if there are implied contracts, if there are contracts that you don't know about by getting driver's licenses and birth certificates and all that, you need to rebut them. But this is going to be part of my amended summary judgment because I believe that I need to bring this up to the case, to the judge. Governments descend to a level of a mere private corporation and take on the characteristics of a mere private citizen, where private, corporate, commercial paper, which is that stuff in your wallet, and securities is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separated from government. Okay? And that's from the Clearfeild Trust Company. That's the United States Reporter, page 363. So 1942. Okay? So it's already been decided, okay? That's what stare decisis means, that when you come at me and you have some kind of a, demand that I pay you, you better be able to back it up with something that's got my signature on it, okay? And if you don't, then, and you can't place it into evidence, then you're outside your jurisdiction and you're committing fraud. So here's Frederick Bastiat pointed out that the state is that great fiction by which everyone tries to live at the expense of everyone else. A corollary principle is the state is the great parasite that sucks the lifeblood out of a society, oftentimes with the support of the citizens themselves. When plunder becomes a way of life for a group of men in a society, over the course of time, they create for themselves a legal system that authorizes it and a moral code that glorifies it. And I don't know about you, but I've had enough. And I was watching a video the other day, and that's why I'm doing a final motion for summary judgment. And I've amended my summary judgment one more time because I wanted to make sure that I backed up my hearsay motion about everything that the Assistant Attorney General is trying to put into the court as being hearsay and not firsthand knowledge. So I went back and read Trinsey versus Pagliaro. You need to write this down somewhere. You need to go look this up. Trinsey versus Pagliaro, very, very good case from D.C. in 1964 in the Federal Supplemental, page 647. Statements of counsel, in brief, or in argument are not facts before the court and are therefore insufficient for a motion to dismiss. Okay, so this is what they put in. They've always put in a motion to dismiss, but you need to step on their toes, man. You need to bop them in the face as soon as they walk into that courtroom. You need to tell them to shut up and sit down. So here's a little video too. This is Trinsey versus Pagliaro. This is a little 9-minute video. This guy goes through it pretty well and goes into it. So once again, I am going to go through my motion with you. Okay, and we put up here that it's my final amended motion. Okay, and the other thing that I did was I cut and pasted Federal Rules of Civil Procedure 56, which is summary judgment. That's what we're asking for. And as we read here, pursuant to your rules, plaintiff moved this honorable court for summary judgment in this equitable case. Plaintiff has now responded to the defendant's motion to dismiss, has noticed the court about the questionable service issues, and if you watch the other videos, you know about those, and praises court will review plaintiff's administrative process and rule equitably. The Office of Recovery Services had a duty to respond and prove a debt exists. They have a duty to the public to answer, prove they have a lawful claim, and they failed. Judgment for the plaintiff should be entered, and the relief requested should be granted. So now here's what we amended. So I went through all, cut and pasted, and according to 56A, 56B, C1A, C1B, okay, all these other ones, I identified each claim on which summary judgment is sought, highlighted and underlined below in bold, okay? So this is Rule 56. You can cut and paste this off the Rules of Civil Procedure, okay? And the court shall grant summary judgment if the movant, that's me, I'm moving the court, shows that there is no genuine dispute, okay? It's a genuine dispute, okay? It's talking about, real dispute. There is no dispute. Why? Because my process has already been completed, right? So there's no dispute. There's no genuine dispute. As to any material facts, who's the one that's putting facts before this court? That would be me, not him. Why? Because statements of counsel are not sufficient, right? And the movement is entitled to judgment as a matter of law, okay? So that's one of them. Time to file the motion. Party must file the motion within 30 days after close of all discovery. Got that? A party asserting that a fact cannot be disputed must support the assertion by, now what have I done? Cited particular parts of materials in the record. I've put in documents. I've put in affidavits. And I've put in admissions. Okay? And showing that the materials cited do not establish the absence or presence of a dispute, or that an adverse party cannot produce admissible evidence to support the fact. Here's a good one here. Objection that a fact is not supported by admissible evidence, right? That's everything that guy, the Assistant Attorney General, has put in. It's all not supported by admissible evidence. A party may object that the material cited to support or dispute a fact cannot be presented in a form that would be admissible in evidence, okay? The court needs to consider only the cited materials, affidavits or declarations, right? Who put in an affidavit, me or him? I did. When facts are unavailable to the non-movement shows by affidavit or declaration that for specific reasons it cannot present facts essential to justify its opposition, the court may deny it, okay? So basically you have to deny it because I'm bringing it up. Issue another appropriate order, right? Okay. Grant summary judgment if the motion and supporting materials, including the facts considered undisputed, show that the movement is entitled to it. Okay? I am entitled. Consider summary judgment on its own after identifying for the parties material facts that may not be genuine in dispute. Okay? So all we got to do, man, is get past this motion to dismiss and get this guy to look at the case. Okay? Affidavit or declaration submitted in bad faith. If satisfied that an affidavit or declaration under this rule is submitted in bad faith or solely for delay, the court, after notice, may order the submitting party to pay the other party the reasonable expenses, including incurred as a result. An offending party or attorney may also be held in contempt or subjected to other appropriate sanctions. Okay? I just brought that up because we all know that he's not a party in fact. Okay? The only thing I changed in here is I want him to rule on the law of the contract, and then I put in here legal costs of $5,000. Okay? Here's my affidavit. Presumption. Now this is another thing that I pulled off the website. Okay? This is from High Frequency Radio. This is OCGA something something. I don't know, but this is out of Georgia Annotated. Presumption from failure to answer a business letter in the ordinary course of business when good faith requires an answer. It is the duty of the party receiving a letter from another to answer within a reasonable time. Otherwise, he is presumed to admit the propriety of the acts mentioned in the letter of his correspondent and to adopt them. In other words, silence is acquiescence, right? You send me something in the mail that says you owe us 25 grand, and I send you something that says prove it, and you ignore it, and then I send you another one saying, hey dude, you're in default and you're starting to bother me. I'm going to charge you $100,000 for bothering me, and they still don't respond. Guess what? You have a duty to respond and either rebut my counterclaim, my counteroffer, or get out of my face. All motions from Mr. Goff are off-point arguments. Okay? It's another thing we'll talk about later. I've got some paperwork on that. When you're talking about off-point arguments, those are the things that the Assistant Attorney General always brings up. He talks about 11th Amendment immunity, and he talks about all kinds of crap that has nothing to do with this case. So you have to mention it. Okay? They have nothing to do with this case. Plaintiff is only asking that the Honorable Judge review his administrative process and rule on its validity. Plaintiffs have come to this court with clean hands and good faith. This is a fact, can't be challenged. The process was done by a notary and the post office. This fact has not been challenged because it cannot be challenged. Plaintiff used an officer of the state for the process, and the notary has verified dishonor. All documents were signed and sent by a third-party certified mail. Jurisdiction is correct in this case because ORS is using the post office and federal zip codes on legal correspondence, which verifies federal court subject matter jurisdiction, and ORS operates on federal funding while enforcing federal child support law. Okay? So it's federal. Mr. Goff has not been sworn in, has not signed any document, has no first-hand knowledge of the case. Therefore, everything entered from the Assistant Attorney General is hearsay and lacks the required liability. ORS failed to respond and prove this alleged child support debt exists. This is a fact and cannot be challenged. This court must rule that ORS has no claim as seen in the process. This process created an estoppel, and ORS is barred from any enforcement or collection activity because of their silence. This is a fact. Okay? And memorandum supporting the facts of plaintiff's summary judgment is presumption from failure to answer a business letter. Wait a minute. In the ordinary course of business, you know what? I got that in there twice. Yeah, I got that in there twice. So we'll have to delete one of them. We got it right up here too. So failure to answer. Okay, silence is acquiescence. All motions from Mr. Goff are off-point arguments, have nothing to do with the case. ORS had a duty to respond. They dishonored plaintiffs by non-response and agreed to the terms of the contract by tacit procuration and silence. Okay? Title 28, 300215A is the United States as a corporation, and all state government agencies are not only corporations, bankrupt, they have no immunity when it comes to fraudulent legal activities and the use of Federal Reserve notes. HJR 192, there's no money, only set off and discharge. How could ORS or the state of Utah be the creditor if they're bankrupt, right? And what exactly did they loan me? Okay? The Clearfeild Doctrine, there it is right there, holder in due course, some contractual agreement. Okay, so we put all that back in there. And here is Trinsey versus Pagliaro. According to your Supreme Court, statements of counsel are not sufficient for a motion to dismiss. He is either counsel or a witness. Okay? So I put that in there now. Here's my claims upon relief, how they can look at and see which relief they can grant me. Okay? There are no facts in controversy. There are no facts in dispute. Defendant is guilty, and this process is valid. Defendant's jurisdiction, process, and immunity arguments have nothing to do with this case. They are hearsay, and plaintiff will not argue with counsel. Plaintiff moves to this court for summary judgment. Okay? And then, of course, you always have your certificate of service. Okay? So I appreciate all of you guys, being patient. This has been quite a struggle with these people. We are not individuals that have gone to court very much. We have not gone to school to learn how to argue. We don't know the law, and they take complete advantage of that. So I have decided that on my off time and to supplement myself and others, I opened up my own website. It's SecuredParty.Video, and we're going to offer information, documents, and I'm going to be an affiliate to High Frequency Radio, SBC University, and you'll be able to just click and go to the link, and you go in, you get some documents, you get a membership. I get $5. So we're going to have videos on here. We're going to have Word documents. We're going to talk about the different courses and the membership choices. It's going to be SPC University, privatesidesolutions.com, and we're going to talk about all kinds of stuff. There's going to be a blog in here that I opened up. By the way, that's me, and that's Utah Highway Patrol. So we're going to have an email address. Just put your email address in here and email me for particulars. And then we're going to have videos and files down here. So we just started this weekend. So I'm excited about this. We're going to do as much as I can. All the stuff that you've seen in my last 50 videos are going to be on there so that you can look at them. There will be a small donation so that you can get these documents in Word format. I'm going to spend some time and some energy putting in, yellow highlighting areas for the date and your name. And I highly suggest that you read these documents and you find out what's really going on in these courts, because the more and more I go in here, the more I can see that it's all fraud. So I invite you to look up SecuredParty.Video in the future. I mean, don't go there now because I just opened it today. But we're going to keep doing videos on YouTube for a couple more months until we get all of my affiliate stuff figured out. And we're going to have a bunch of stuff on the website. And then I might do a Patreon or something and, get $1 a month or $2 a month or something. And we'll have weekly videos and weekly documents and stuff. And I'm going to spend some time, man, because I really want to help. But again, we're not going to go too much farther until we get summary judgment on this case, because I don't know about you, but I wouldn't listen to somebody unless they've won their case and they've been in court. So peace, and you guys have a great weekend.